6 key employment law changes. These 6 key things came into effect on the 6th of April. The big news was this Act of Parliament, which was rigorously debated last year, and it came into force. It passed into law on the 18th of December, so they just got it in before the end of the year. The changes are being brought in over the next couple of years. Some are set out in regulations already. Some are actually still being discussed. The first big tranche was the beginning of this month, and there's the ones we're going to be going through today. Just to note that the ones that I think are properly big time are going to come in October, and we'll have another update before then, and those changes will be about harassment, so employers being liable if their employees are harassed by third parties. Tipping, there's going to be laws about tipping. Time limits to make claims will be going from 3 months to 6 months. So if you dismiss somebody, you've got to diarise it for 6 months plus a month for ACAS. So that's a long time to wait whether an employee is going to come back at you. And a few more trade union changes. And then in January next year, which seems like a long way off always, but it is only 9 months away, we've got the right to claim unfair dismissal going from kicking in after 2 years to 6 months. So you have to make a decision about whether an employee is fit for the role quickly. They have to keep on best behaviour for 6 months only, rather than the first 2 years. The cap on compensation, which is currently £123,000 or a year's salary, whichever is the lower, is now going to be removed in its entirety. So it's going to be like discrimination. No cap on compensation. That makes unfair dismissal properly scary. And the ability to dismiss and rehire will be removed. But let's have a look at what they've brought in April. Before we start, session's 30 minutes. Drop questions in the chat as we go. Cameras off is absolutely fine. No jargon. We are recording this, so if you want to replay it later, God help you, then you can do. So one of the issues, right, is that there are more rights for employees now than there used to be. This is ever increasing. Nobody seems to come in and get rid of employee rights. Getting decisions wrong in respect of the things we're going to be talking about can lead to tribunal claims, compensatory awards, which I've just said are going to be increased to unlimited, and of course injuries to feelings. This can lead to reputational damage. It's disruptive for people in the business, whether you're managing the business or sitting next to somebody who's just decided to sue. It's disruptive. For small businesses in particular, a relatively modest award can be incredibly time consuming for the people in charge. And it can wipe out your profits for the year, which means that every decision now carries yet more risk. Policy gaps. What happens if your policies and procedures are not up to date? Well, in theory, nothing, unless somebody wants to use them. And if you're playing a game with the wrong rules, you're gonna lose at some point, right? Managers will rely on the wrong rules and get it wrong. Employees get the incorrect information. Decisions are based on policies that are no longer lawful. I really found this when they scrapped the retirement age, when they scrapped retirement as a reasonable reason to dismiss somebody. What happened then was that not everybody got the memo, and people were being dismissed because they were 65, because that's what the retirement age was at the time. And they were being sued for unfair dismissal and age discrimination. And there was simply no defense to that. Yeah, we dismissed you because you're 65. It didn't happen a lot, but it happened I remember advising, I don't know, at least half a dozen people on changing the policy so that not everybody was relying on the wrong rules. Relying on the wrong rules is one of those things that can come up and bite you when you least expect it. And of course, the other thing to bear in mind, and I think we're all aware of this, is that employees are increasingly aware of their rights. I know my rights. You hear that quite a lot, and strident and quick, much quicker to enforce them. Particularly younger people, I found, they'll go rather than try and resolve a dispute with a colleague informally, maybe having a quiet word or having a quiet word with HR, straight into grievances. So we have to be aware that this is going to become more and more common, and that you need to be on it. Basically, there is less flex in the system. So there were 6 employment law changes that came into force all at the same time. And as it says, some affect day-to-day processes, some less so. And this is what we're covering: parental leave and parental leave as day one rights, statutory sick pay, protective awards in collective redundancy cases, sexual harassment as a qualifying whistleblowing disclosure, easier trade union recognition, launch of the Fair Work Agency. I've got something to say about that. Day one rights and sick pay. Paternity and paternal leave, no more qualifying 26 weeks. You get the right to paternity leave and parental leave from day one. Just something else to add on to this slide is that separate regulations, not under the Employment Rights Act, but there are now regulations dealing with bereaved partners' paternity leave. So in an old-fashioned world, using old-fashioned language, if a woman dies in childbirth, for example, which happens more commonly than we sort of imagine, their partner has the right to benefit from what would have been their maternity leave. So the same maternity leave, the same maternity pay provisions, and the same maternity pay leave, but it's called bereaved partners paternity leave. And I was just discussing with Julie how, well, thankfully this is not very common, and she said, it happened to a friend of hers. So it's not necessarily that unusual. Just bear in mind that there is something out there. Statutory sick pay, no longer a 3-day waiting period. Lower earnings limit's been removed. And it's so the 3-day waiting period means that SSP is payable from the first day of absence for all workers. Just something to bear in mind. This is quite a big one. Collective Redundancy Protection Award. So the rules about consulting for collective consultation or redundancy when you've got 20 or more employees and upwards. If you get it wrong, the fine, because that's what it is, it's not about compensation, it's a fine, has increased from 90 days, from 3 months pay to 6 months pay per employee. And that's gross, right? So if you have, and obviously if you've got 20 or more employees, there's a lot of people involved, and you get rid of, let's say, 20 people, that's 10 years average salary you have to pay. 10, is that right? It's a lot of money anyway. When you say these things and you think, hold on, I've got that wrong. No, it's 10 years, isn't it? 20 people, 6 months, that's 10 years. 10 years, like having 10 employees, or one employee for another 10 years. That's the level of compensation. It's a lot. And that's if you don't properly consult. And there is always pushback on on collective consultation because it's considered to be disruptive. Well, it is disruptive, obviously. So people kind of go, well, how much notice do we have to give? How much consultation? Can we do less? There's lots of anti-avoidance provisions in collective redundancy consultation, and this is really to encourage even more, if it wasn't encouraged enough, people to work hard at it and make sure it's done right. Sexual harassment and whistleblowing. Sexual harassment is now a qualifying whistleblowing disclosure. If an employee raises sexual harassment, they can raise it under the whistleblowing legislation. I think the idea is that if somebody is being sexually harassed at work, it is not beyond the realms of possibility that they're not the first person who has been sexually harassed at work, at this particular place of work, nor that it may well not be they may not be the first person harassed by this person, or it may well be that there is a culture of allowing this kind of stuff to happen, like we heard about in McDonald's recently. If you raise sexual harassment, it is entirely possible that there's a wider issue there, therefore public interest. So that's what that's about. It didn't used to be the case. It's now absolutely crystal clear that that is now the case. Recognition, enforcement, and new watchdog. There was I think it was Amazon. People have been wanting to unionize in Amazon warehouses, distribution warehouses, and the threshold for getting enough people to vote for trade union recognition was at a certain point. And I don't know whether I read this or I just made it up, but I'm pretty sure I read it, that Amazon were recruiting people temporarily to make sure that the threshold couldn't be reached. And therefore there wouldn't be a vote for trade union recognition. As soon as that kind of stuff hits the newspapers and people have a bit of political will, what happens is that with the best things, they change the law to stop that kind of stuff happening. The law is always catching up. We're never ahead of the game. The law is always catching up to stop this kind of stuff. But it means that trade union recognition will be easier. Of course, it's a Labour government. They are financially supported by the Labour Party, by the trade unions. In a sense, the Labour Party is the political wing of the trade union movement. So obviously they're gonna try and turn around some of the trade union legislation which took place during the last 14 years of Conservative Party rule. The Fair Work Agency, now this has been brought in. It's a single enforcement body for employment rights. It's going to focus on minimum wage, holiday pay, and worker protection. It's a new kind of organisation which we haven't had, which is like a government body to enforce these things in the workplace. Now, until now, it's been up to individuals to say, I'm not happy about this. The thing about the Fair Work Agency, and obviously we haven't seen how it's going to work yet because it's only just kind of got up and running. But if you've had a look at their website on the government website, what you will see is the front page. Right at the top, the first two links are complain about pay and workers' rights and report serious issues of abuse and exploitation at work. And if you click those, it takes you to a form to fill in. It could not be easier to complain about your workplace. So this is alerting the Fair Work Agency to problems in the workplace. I have my doubts sometimes about this kind of stuff and about feedback. We got a 1-star review on Google because somebody called and asked if this firm did wills and probate work. And we said, I'm really sorry, we don't do that. We do employment law and family law. As a result of which, they gave us a 1-star review because we didn't do the kind of law they wanted. Well, what are you going to do about that? So, you can imagine those are the same kind of people who, may well complain to the Fair Work Agency about stuff which is sort of outside their remit, perhaps. I just hope they've got a grown-up and not AI who is filtering some of these comments that are coming through. Anyway, they couldn't make it easier to complain. The new duty to keep holiday records. Okay, holiday records. There's stuff on here. You're probably all aware of this, but you've got to keep holiday records for at least 6 years. That's important. You have to keep records of people's, holidays, pay, whether they've carried time over. Are 0 hours workers getting adequate holidays and holiday pay compensation? And if you get it wrong, it's a criminal offence. A criminal offence, punishable with a fine. From what I've seen, the fine is unlimited. I heard somebody the other day say it's also punishable with imprisonment. I couldn't see anything that said that, but it might be tucked away somewhere. The point is, you can be labelled a criminal if you don't do this properly. The enforcement powers for this are not yet in place, but it's coming very soon. They reckon 2027, probably early 2027. So you've got, until then to get your ducks in a row, make sure, you're counting all the right people in all the right ways. But that's if you are keeping if your holiday records are on a spreadsheet, I think probably it's time to invest in some proper software. So just those are the 6 changes that are coming in. The rules aren't optional. You've got to update your policies, and obviously the updates need to be right. So you've got to transfer what the regulations say into some kind of usable policy. A little bit of translation going on. The people who deal with these things need to be trained, right? So, and I can think of an example of somebody, a manager who kind of authorizes people's holidays, being a bit relaxed about it, and somebody books a holiday and then they cancel the holiday, and he cancels the holiday, and then they book it again and they say it's from the one I had before, and you can just see if it's all being done in a way which might have been acceptable before, probably not acceptable anymore. Obviously, the best policies are the ones that the best processes. A policy is what it says. A process is how it works. The best processes need, in a perfect world, to be clear and easy to understand and to use. Needless to say, we can help you with that if you wish. In respect of briefing managers, in a sense, if they have to do something, then you've got to make sure that they know how to do it. A lot of the time, managers just need to know that if something like this comes up, they need to talk to HR, or they need to talk to me, or they need to talk to whoever is in charge of people. Just sometimes, they've got jobs to do. They're in quality control. They've got 6 people working for them. They need to know what to do about holidays or grievances or whatever it is. Really, all they need to know is if something like that comes up, oh yeah, I had a chat with somebody about that. I need to find out. I need to check. Let me just check. That's really what they need to do. If you sometimes you overburden people with information, sometimes they just need to check. So the practical steps. This is obviously in addition to your normal day-to-day 40-hour week. You've got to review your employment contracts in case it's relevant. You've got to review your staff handbooks, and if there are policies that sit somewhere else. I mean, I have had some clients who have It's policies all over the place, you know, and they've got a handbook and they've got policies here and policies here and policies here. They just need to pull them together, and there was never any management incentive or will to do that. So they just had to kind of deal with that. So anywhere your policies are, you've got to have a look at it. And as I say, brief managers on these new rights, they need to know that things have changed. They need to know that they need to know. What they don't need to know is the detail necessarily. That's what I would say. We can help. Obviously, that's what we do, right? We help people in this kind of situation. If you want a 15-minute chat to see how compliant you are, I'm happy to do that. I'm not a salesman. I feel very uncomfortable selling. I'm essentially a technician, right? We do the technical side of this. So if you do give us a call, I'm not going to sell to you. Hopefully I will demonstrate that I'm useful and I know what I'm talking about, and that, you know, you might want to instruct me formally, but I'm not going to sell to you, because that's just, you know, makes me feel a bit queasy, frankly. What we do have here is a product which I've been working on for donkey's years. Never managed to get all the bits and pieces right, but the key point, the key problem with lawyers is we're expensive. So, you know, you think, well, do I need to call a lawyer? I might need to call a lawyer. And then that hesitation might cause you to not call a lawyer, and then make the wrong decision, where a quick call, a nudge in the other direction might have avoided pain. So we've got this this retainer where you get unlimited support. It's, you know, telephone, email, face to face, however you want to do it. You know, you've got access to the solicitors on my team, the least qualified of whom is about, I don't know, 17, 18 years. I've been doing this, I counted the other day, for 33 years. Honestly, 33 years I've been doing this. So you get access to us. You don't get access to a clerk with a spreadsheet on a computer, or somebody whose natural inclination is to say no. Our natural inclination is to say, not like that, but maybe we could do it like this, to try and help positively. We'll look at your contracts and handbook. If it all goes pear-shaped, there is employment tribunal insurance. So you get sued, your fees are covered. You lose, any compensation is covered. Obviously, that's going to get more and more important as the, you know, as the limits on compensation decrease. What it really means is that you don't have to worry about employing people anymore. There's no, it becomes de-risked. Is that a word? I think so. De-risked. I've heard people say that. Okay. So we're 25 minutes into a 30-minute sesh. If you have any questions, oh look, another sales thing that my people have put in here. We can have a 30-minute chat. We can have a 15-minute chat, or we can have a 30-minute chat. It's entirely up to you. We can have a 5-minute chat if you wanted, or a 40-minute chat. So if you want to book something, have a look at the QR code, and you can book something straight in with me. And we can have a chat face to face, or not, if that's your preference. But now we've got 5 minutes for questions. Chloe, do we have any questions?
We haven't got any on the chat at the moment. If we do get any come up, please pop them in now. We had a few come on through social media, if you're happy to go through some of those. Does the day one SSP right apply to 0 hours workers as well?
It applies to everybody. So a zero hours worker, if you are scheduled to work, you know, on Monday, and you call in sick, you're still entitled to sick pay. I mean, if you're not scheduled to work and you're sick, it's like being sick at the weekend, I guess, for people who work Monday to Friday, 9 to 5. But if you're scheduled to work and you're not able to work because you're ill, yeah, you should be entitled to SSP.
Fantastic. One's just come in on the Q&A. Great session. Is HR Shield a fixed price or a sliding scale?
Well, we charge more for people with 100 employees than we do for people with 5 employees, put it like that. But it's sort of a price per head, really. The fewer people you have, and the reason it works like this, right? If you have 5 employees, it gives you enormous peace of mind, and it means that if you get sued, it's not going to be the end of your business. But with 5 people, you're not likely to call. With 100 people, you are likely to call, but you've probably got 2 or 3 people in HR who can deal with most issues, properly and well anyway. So again, you're not likely to call. The most expensive bit of it really is the insurance. But and I've got clients who I was going to say thrash the system. They don't thrash the system. They just use it when they need it, and they get value for money. And other clients who rarely call. But as far as I'm concerned, as long as I'm not losing money overall, it's all good. So yes, that's a very long way of saying, yeah, it's a sliding scale.
Other question that actually came up a couple of times is, how quickly do we need to upgrade our contracts and staff handbook?
Well, the rules are the rules now, so the answer is yesterday. But really, the only time you ever need to change these things is when somebody needs to use them. So if you don't have an updated policy on sexual harassment or something, then it's only relevant if somebody ever relies on it. If nobody ever relies on it, it doesn't really matter, does it? But I would say you should get on with it. It needs to be on your important list, even if it's not on your urgent list.
Yeah, one that's just come in, I'm going to just read it as it's written. What's a threshold to prove that a sexual harassment claim was made, e.g. in writing, verbal to a manager or other senior member of staff? We can take that offline if it needs a little bit of clarification.
Just say that, just read it to me again.
What's a threshold to prove that a sexual harassment claim was made, for example, in writing, verbal to a manager or other senior member of staff?
Well, this is really a question of evidence. I love questions of evidence. I specialised in evidence at university, actually. So evidence is, if somebody says I did this, and the manager says I reported sexual harassment to you, and the manager says no, you didn't, then it's the question is, who would a judge believe? That's really it. If it's in writing and there is proof that you sent it to somebody on a relevant date, that's quite persuasive. Verbal evidence is more difficult to prove. But I mean, just to kind of take it to its most fundamental level, the vast majority of rape cases are about consent. They're not about whether sex happened. They're about consent. Did you give consent as a woman, or did you withdraw consent? And did the man believe you'd given consent? Well, there's 2 people there, right? You either believe him or you believe her, and that evidence is just who's more credible, and is there any surrounding evidence which would be consistent with what they're saying now. I've got nothing else to say about that. Any other questions?
I'm just having a look. I have had one that came through, which was, we have a staff handbook. It hasn't been updated in a few years. Where should we even start? I think was the.
Give me a call. Give me a call. We can do that for you. Or look online. I would be reluctant. We just a quick note about AI. I would be reluctant to run it through ChatGPT. ChatGPT seems to be good most of the time, but we're getting increasing amounts of stuff from people on the other side, from individuals, from employees who are complaining about their boss. We're in litigation. They're sending AI stuff. It's obviously AI. It just, you just see it. It's obviously AI. There's a lot of words where there are fewer words could be. and probably most of it is not right. No, most of it is irrelevant or not right. And it's unpersuasive. If you run your handbook through AI, I don't know, maybe it'll get better. Maybe in 2 or 3 years' time it'll get better. At the moment, I would say you don't want to bet the house on this policy which we AI'd. We're pretty sure it's good because AI said it, because ChatGPT said it was. I don't know, that's a bit risky. So I wouldn't go for AI. Get an HR advisor to do it. Hire us. Hire another lawyer. Get professional assistance is my advice.
Fantastic. That is 11 o'clock. It's 2 minutes past.
Okay. If anybody wants to follow up with me individually, either do the QR code or give me a call, that's absolutely fine. And you just need to be aware that these things have changed, right? And then it's up to you what you do with it. And they're coming in waves. There's going to be more stuff coming. Just bear that in mind. Anyway, nice to present to you all. Thank you very much for your time. I hope it's been useful. If I can help, let me know. And as I said, I'm not a salesman, and so you're not going to get trapped into a relationship like we all have with Netflix. Like trying to quit Netflix is like impossible. Yeah, that's not going to happen. So that's it. Thank you very much for attending.